This video is about patent infringement in Germany for defendants before the complaint is filed. So, for example, you are launching a new pharmaceutical product in Germany and there is a patent that you are aware of that is very similar to your product. Then you might want to take precautionary measures to increase your chances of success in potential patent litigation in Germany. So, first of all, some statistics. In Europe, there are around 2,000 patent infringement cases each year, and 1,200 are handled by German courts. So the large majority of all patent infringement litigation happens in Germany. Just for comparison, the UK has around 50 patent infringement cases every year. Italy and France have around 250 to 300 cases every year, and there are around 14 countries where there is no patent litigation at all. Within Germany, the court in Düsseldorf plays the major role. Around 500 to 600 cases are filed every year. Other important courts are Munich, Mannheim, Hamburg, and basically every state in Germany nominated a specialized patent infringement court, but some courts don't really get a significant number of patent cases. If you want to learn more about these statistics, I have written an article about these statistics with one of the most important patent litigation judges in Germany, Thomas Kühnen, and you can just send me an email. The contact details are below this video, or leave a comment below this video, and I will be happy to elaborate on the statistics for patent litigation in Germany and Europe. So what do you have to fear as a potential defendant in a patent litigation case in Germany? Of course, there can be a complaint, but also, more importantly, in Germany it's possible to get a preliminary injunction for plaintiffs on a very short notice. So a plaintiff can request a preliminary injunction with a court, and a court might decide within 1, 2 or 3 days to issue a preliminary injunction, and you would have to stop offering, producing or selling your products immediately. Then there is, of course, the chance that you get a cease and desist letter, and I will talk especially about the preliminary injunction later on in this video. One strategy can be that you search for prior art and see whether you can invalidate the patent. And you don't really have to file any invalidation proceedings with the Bundespatentgericht, the Federal Patent Court, or file your arguments later in the patent litigation case, but rather you can basically make a draft for cancellation action against the patent, a nullity suit, and you can send this to the patent owner and ask them for a free right to use the patent in exchange that you do not attack the patent with the enclosed draft. If you have good prior art and good arguments, the patentee might start discussing with you because he wants to, the patentee of course wants to keep the patent to also be able to go after other infringers. They might give you the right to use the patent, basically not file any complaint against you. This strategy of course has its weaknesses. If you are asking the patentee, then you are basically telling the patentee that you are possibly infringing their patent. So you have to be very sure, and it has to be a quite clear case that you can invalidate the patent. Otherwise, it would not be really useful to use this strategy. Then what you can do to counteract the preliminary injunction, the request, you can file a Schutzschrift, a protective letter with the relevant courts, and a so-called electronic registry for protective letters in Germany. In this protective letter, you would basically outline your arguments against patent infringement, so basically non-infringement arguments and invalidity arguments against the patent, just enough to make the court think twice before issuing a preliminary injunction. So keep it to the point, keep it concise, keep it under 20 pages if possible. I have discussed with a couple of judges that they don't really like to read tons of pages, so if you can keep your protective letter short, it's probably a wise decision. Before launching a product, or at the latest at the launch date, if you are aware of a patent that you could be infringing, then file a protective letter with the respective courts. Then finally, one thing to think about would be instructions to the people at the doors of your premises. Basically, in Germany, it's also possible to have some limited way of discovery, a discovery process, where an independent court expert can appear at the doors of your different offices or manufacturing locations or research facilities, and they can request to look at your product, or especially your process and methods that you are using. So, and the people at the door might not be well prepared to handle this kind of situation. So before launching a new product, you might want to make a one-page information, not more possibly, for the people that are guarding your doors of the different locations, where you basically state in case that there is an independent expert from the courts, what they would have to do. For example, ask for the permission by the court that they can search your facilities. If they don't have that, then they would have to go back to the court and ask for that permission to enter the premises. Then you can ask them for 2 hours time, basically, at least in Germany, to wait until you have an attorney on site. Then, of course, you want to ask the person at the door, to seat the independent expert in the waiting room until the attorney is there, and watch the independent expert. And of course, all different kinds of instructions. If you want to learn more about this, I have also written an article about this procedure. Just drop me a line in the contact details below this video, or send me a comment under this video and ask for it. So if you like this video, hit like, subscribe to my channel, and most importantly, protect your intellectual property and go make it count.